Thank you, Vice Chair Campbell, Chair Creighton, and members. Just here as a resource, I'm the Chief Legal Analyst at IDRA. We are opposed to this bill. My colleague, Dr. Chloe Latham-Sykes, testified earlier as to our position, and I'm here today to be a resource to answer questions about some of the provisions in the bill.
So I appreciate.
Thank you very much, Senator Menendez. You're
Madam Chair. I
recognized.
appreciate that. So earlier today, I was asking Ms. Dr. Latham-Sykes questions about the legal concerns about the bill. As you are the chief legal analyst, could you explain the concerns that you all have about the bill as drafted? I am not an attorney, but I'd like to know, because I'd like to know what potentially we could be setting ourselves up for. Sometimes, someone said it earlier, the devil's in the details. It's a 28-page bill, and however well-intentioned, I know sometimes the chair wants us to do something. His intention is to do this, but the drafters of the bill may not have interpreted it correctly and not gotten the words right. So could you tell us what your concerns are?
Sure, and I suppose the concerns are sort of in two categories. Thank you for the question, Senator. First, as a general matter, is our position that any program, including the proposed ESA that diverts public funds into private schools, would violate the Texas Constitution. And so that's a deeper conversation. Happy to visit with members about our concerns in that regard, but point blank. And we know that this concern has been anticipated because in this legislation, there are two provisions really addressing how a legal challenge would be brought to challenge the constitutionality or other validity of the program. So first, Section 3 of the bill does create a pathway, and the legal term of art is legal standing, for certain stakeholders in this program to intervene in any litigation that would be brought to challenge the constitutionality of the program. The eligibility of that standing is limited for that special intervener status is defined as program recipients, so students and families who receive the funds, vendors who provide educational services, and that's a really broad category, anybody who gets money under the program in order to administer services through this legislation, and of course the education providers themselves, the schools who receive the recipients, and so they would essentially get a step ahead. Typically, when you file litigation, you have to have legal standing, and prove and establish that through the course of litigation, and that's a determination for a district court. There are rules for establishing that. It's been the subject of our case law recently, but this legislation gives voucher proponents a leg up in terms of just creating an automatic right of action to intervene, and we think that's not fair for all of the students and families who might want to challenge this provision.
Is that a first? Would that be new law?
Certainly, because the establishment of a voucher program is a new program, in totality it would be new. We are aware that other states that have adopted voucher programs have attempted to include provisions like this. We know that there are many actors, including well-funded actors, who are at the heart of drafting and supporting the development of this type of legislation, and we have no doubt that they are really the stakeholders who are looking to amplify their influence not only here in the policy process, as is their right, but directly to our judges and to ultimately the Texas Supreme Court.
And so this creates an unlevel playing field.
It does, and that's amplified in Section 7 of the bill, which then creates a more robust process for regarding the litigation of any kind of legal challenge. And that section of the bill, based on, we only got this bill at the last minute, so it is a preliminary reading and would welcome if there is any misunderstanding there. But my best read of that provision is that it fast tracks and expedites the resolution of this litigation. And certainly there are really significant stakes at issue here. This is an issue of first impression for Texas. We never had a voucher program. We never had a program like this. And it's one that should be weighed very carefully. It's one where the record should be developed very robustly, and it's one where our traditional civil litigation process is well suited. We've had school finance litigation in the past where it's been critically important to understand the impact of these programs, particularly given the discrimination concerns, the efficiency concerns. And so my reading of this bill is that it gives a 15-day window to file an appeal, and it further stacks the playing field against traditional public schools and students and families in those schools by ensuring that if a district court does, in fact, find that this program is unconstitutional, that ruling doesn't matter. Automatically, that ruling is stayed until it's resolved by the Texas Supreme Court. And so that's already creating a presumption of unfairness.
What would the normal course be? Wouldn't it be an appeals court?
Certainly. So in two ways, it's different. First, because it is a fast track, an accelerated and expedited appeal jumps over the Court of Appeals process, right? So directly from the district court, directly to the Supreme Court. The bill tells the Supreme Court, you got to review this first, no matter what other really important issues that you're dealing with. I'm a former law clerk, Texas Supreme Court for Justice Jeff Boyd, and I've seen firsthand the important things they deal with. So this bill is telling the Supreme Court that doesn't matter what else you got on your docket, you got to hear this one on an expedited basis first. And then in addition to that, typically a district court order would remain in place until it goes, through the normal process, reviewed by a court of appeals, and then the Supreme Court. So this really jumpstarts that process.
All right, last question. This adversely would impact the position of a school district or a nonprofit in a lawsuit, would it not?
I agree.
Okay, thank you, Madam
Thank you.
Chair.
Thank you, Senator Menendez.